Welcome to the IPC's presentation on access to information under the Child, Youth and Family Services Act. Part 10 creates new access and privacy rules for collecting, using, and disclosing personal information in Ontario's Child and Family Services sector. These new rules, which take effect January 1, 2020, apply to service providers who are funded or licensed under the Child, Youth and Family Services Act. They include children's aid societies, group homes and foster care agencies, and those providing other services funded under the Act. During this presentation, you'll learn about an individual's rights when it comes to accessing their personal information and best practices for processing access requests. The Office of the Information and Privacy Commissioner of Ontario, the IPC, oversees the province's privacy and access laws. This includes the new access and privacy rules for Ontario's Child and Family Services sector. As part of its mandate, the IPC investigates complaints from people having difficulty getting access to government information or their own personal records, and provides resources and information to hospitals, provincial ministries, municipalities, and other organizations to help them comply with Ontario's privacy and access laws. To learn more about us, visit ipc.on.ca. Part 10 creates an access and privacy framework for personal information used by service providers to deliver programs and services licensed or funded under Ontario's Child, Youth and Family Services Act. Personal information means recorded information about an identifiable individual. It can be recorded in many ways, including paper or electronic records, video or audio recordings. Personal information doesn't need to include a person's name. Under the law, any detail that could identify someone is considered personal information. Examples include things like age, education, gender, medical history, or notes from a conversation with a counselor. Even if this personal information was recorded before Part 10 comes into force on January 1, 2020, it is covered by the requirements of this new law. Under Part 10, individuals have the right to ask to see or receive a copy of their personal information and request corrections. Service providers cannot charge a fee for providing access to records or corrections, and in most cases they must respond to these requests within 30 calendar days. Individuals must submit their requests for access or correction in writing. A request should contain enough detail to make it possible for service providers to find a record, and if more detail is needed, service providers are required to help the individual fill out their access request with additional information that will assist them in finding the record. Once an access or correction request contains the required information, the 30-day timeline for responding to it begins. When reviewing an access request, service providers must first consider, is the individual requesting records of their own personal information? And is the information being requested related to providing services to the person who is asking for it? As we mentioned earlier, Part 10 only applies to personal information used to deliver programs or services licensed or funded under the Child, Youth and Family Services Act. If someone asks about records that are not related to a program or service provided under Ontario's Child and Family Services Law, Part 10 does not apply. If the information they are asking for is subject to the rules of Part 10, the right of access only applies to personal information related to services they have received. Once you've established that a request is related to the delivery of a service that an individual has received under Ontario's Child and Family Services Law, you'll also need to determine if the record is in your organization's custody or control, or if the individual should be submitting their request to another organization. Generally, if you have possession of a record, it is in your custody. However, in today's digital landscape where files are shared back and forth instantly, simply having the record is not enough to determine custody. You must also have a work-related reason for possessing it and some measure of responsibility for what happens to it. In some cases, even if a record is not in your custody, it can still be under your control. For example, a record that is in the possession of a consultant who works for your organization. While you may not physically have the record, it can still be under your control if you have authority to manage it and you rely on it for business purposes. It is also possible to have custody or control of records that were originally created by another organization. If a child is referred to you and you maintain and rely on the referral records to provide services to the child, it is likely the records are in your custody and control, and the child has the right to ask you for access to them. When an individual asks for access to the personal information in their record, there is no general rule requiring you to remove the personal information of other people before granting access. How you deal with the information depends on whether or not the record is dedicated primarily to providing services to the person requesting access. If it is, they have the right to access the entire record, even if it contains information about other individuals and other matters. If it is not, they have a right to access only their own personal information from the record. It is important to remember that just because a record is filed under an individual's name, it doesn't automatically mean it is dedicated primarily to providing services to that person. This may be true for some records, but won't apply to others, and each access request must be considered on a case-by-case basis. Now that you've reviewed the request and determined that it is for personal information that is in your custody or control, and it's related to the delivery of a service to the individual under Ontario's Child and Family Service Law, you'll need to determine if any access exceptions apply to the information in the record. We touched on these 6 access exceptions briefly in our introductory webinar on Part 10, available on the IPC's YouTube channel. If an exception applies, service providers can refuse access to all of the information it concerns. Under Part 10, individuals do not have a right to access a record of their personal information if it is subject to a legal privilege, another law or court order prohibits its release, the information was collected primarily for a proceeding that has not concluded, providing access could result in a risk of serious harm to any individual, it could identify someone who is required by law to provide the information, or it would reveal a confidential source and you consider it appropriate to keep their identity private. In the case of the last 2 exceptions, this does not mean withholding all the information provided by people who were required to do so by law or who have done so in confidence, just any information that might identify them. Service providers must respond in writing to an access request within 30 calendar days. The response will grant access by making the record available, refuse access to the record or parts of the record, explaining why and including details about the individual's right to appeal the decision to the IPC, or extend the deadline for providing a response. The timeline for responding to an access request can be extended for up to 90 days. The response time can be extended to accommodate the size of the request or the time needed to search for records, or because of the time needed to assess the individual's right to access the information. Similar to access requests, service providers must respond to requests for correction to records within 30 days with a possible time extension of up to 90 days. Service providers can refuse to correct a record if the information in dispute is a professional opinion or observation, or they did not create the record and they do not have the knowledge or authority to correct it. When a service provider refuses to correct a record, they must explain in writing why the request has been denied. They must also inform the individual of their right to prepare a statement of disagreement that will be attached to the record. It is not always an individual who requests access to their personal information. In some cases, a substitute decision maker can request access to someone's personal information on their behalf. Parents with custody can act as decision makers for children younger than 16 years old and may request access to their personal information with some exceptions. For example, a parent with custody of her 14-year-old daughter asks for access to her daughter's records. The daughter makes it known that she does not want her parent to have access. Provided she is capable, the daughter's wishes overrule those of the parent, and the parent's request for access must be refused. Additional information about how to determine if someone is capable and who can act as a substitute decision maker is available in the Part 10 guide for service providers available on our website, or in our first webinar on access, privacy, and the Child, Youth, and Family Services Act, available on the IPC's YouTube channel. Under Part 10 of Ontario's Child and Family Services Law, all service providers are required to provide the IPC with a report on how many access and correction requests they've received in the previous year. This report must also include statistics on how long it takes your organization to respond to access requests, as well as data related to certain kinds of privacy breaches. You must begin collecting this information as soon as Part 10 takes effect on January 1st, 2020, so the ability to track statistics is an essential element to include in your systems for responding to requests for access or correction. More details about what statistics to track and when to submit them are available in the Guidelines for Submitting Annual Statistics to the IPC available on our website. The focus of this presentation has been on access and correction requests under Part 10 of the Child, Youth and Family Services Act. If you haven't done so already, we encourage you to visit our YouTube channel to view the first video in our series on Part 10. It provides an overview of requirements for consent, substitute decision makers, and notifying individuals about how their personal information could be used. For more detailed information about access and privacy rules for Ontario's Child Family Services sector, visit our website to download the Service Provider's Guide to Part 10. Our website contains a variety of resources and guidance, including brochures, posters, and other materials to raise awareness of access and privacy rights among children, youth, and families. And our Twitter feed is the place to get all the latest IPC news and updates. Thank you for joining us today. Contact us if you have questions about this presentation or access and privacy in Ontario. We can help.